Hi, I'm attorney Ricky Malik, and today what I would like to talk to you about is the Violence Against Women Act, also known as the VAWA Act. VAWA is the acronym after the term. And specifically, what VAWA is for persons, generally the spouse of a U.S. citizen or a lawful permanent resident, that's a green card holder, who have been the unfortunate victim of physical abuse, that is battery, and or extreme cruelty. It is also available not only to the spouse, the immigrant spouse, but also the children of that abused spouse. So, for example, if a lady was married to an American citizen and it was abusive not only to her but to her children, all her as well as her children under 21 who meet the definition of a child under the Immigration Act would qualify for a VAWA filing. Now, in order to file under VAWA, there has to be quite a few requirements that are met. Firstly, the person must be in the relationship to the abusive U.S. citizen or green card holder, or must file within 2 years of the termination of that relationship. The relationship normally terminates in one of three ways. There's 3 Ds: death, deportation, or divorce. So if any of those events have occurred, the VAWA petition must be filed within 2 years of that date, and that's a statutory deadline. So the exceptions, are not really there. It just needs to be filed within those 2 years. Now, any credible evidence will be considered for a VAWA filing. Whatever evidence there is, whether it be affidavits from the person, police reports, affidavits from friends, because evidence of abuse is oftentimes difficult. The abuser doesn't leave a trail, will not issue you a note. Oftentimes there's a lot of cover-up. When there is physical abuse, such as the abused victim, even if he or she does seek medical attention, may say that she hit a door or some other excuse to indicate that there was an abuse. So this is a very difficult issue to deal with, but it can be overcome, and we've successfully been able to do that in quite a number of cases. Secondly, you have to prove the status of the abuser, that the person was indeed a U.S. citizen and lawful permanent resident. This is quite a challenge in situations where the abused person has moved out of the abused house or has already divorced the person or the relationship has ended. But it's something that really needs to be worked on to prove that this person was indeed a U.S. citizen or a green card holder. Another concern that people often have is, what will the abuser know? Now, these petitions are filed and they're all adjudicated by a special designated unit at the Vermont Service Center. And it's almost, in fact, it is a sealed unit in many senses. The abuser will never find out about what is said about him or her, in support of the VAWA petition. Even when they try to, or even in the most extreme situations, or even when the abused person still lives with the abuser, the mail will not go even to the abuser, but rather to the attorney of record or a designated in-care of address, because they're very aware and sensitive to the situation where an abused person may still live with the abuser. Another requirement is that the marriage has to have been bona fide and real. They look to make sure, and this can be proven in several ways. Obviously, a shared residence is one, and evidence should be submitted indicating names on documents together, pictures to show that it was real, as well as marriage license and any other evidence that could establish that this is indeed a good faith marriage. And this shouldn't be understated, because again, in abuse situations, and oftentimes there's already separation by the time a person comes to talk to the immigration attorney about what to do. There's very, very little evidence that could be available, but some has to be found one way or another to prove that it was a good faith marriage, or at least at the initiation of the marriage, both parties intended to establish a life together. Now, there is a slight exception in terms of the marriage. Sometimes there are cases where an abused person genuinely believes they are married to a U.S. citizen or green card holder, but actually find out that they're in a bigamous relationship. So there are exceptions for that. Again, when it can be proven that in good faith the person believed that they were genuinely and legitimately married to a U.S. citizen or a green card holder. Another requirement is that the abused person must demonstrate that they are of good moral character. And this cannot be understated enough. Oftentimes, in fact all the time, we have to submit police reports from any jurisdiction the person has lived for 6 months or more to show that there's no criminal history. Now, having a criminal history does not preclude or stop someone from getting VAWA benefits, but you must prove then rehabilitation, remorse. You have to address these issues because if there are serious crimes or problems, that may be a bar to getting VAWA. So this is something that has to be explored candidly with your immigration attorney in terms of what's the appropriate action to take upon filing. And then once everything is filed, there's an adjudication process, and then if approved, the person is granted essentially deferred status. The person can then apply for a work permit, and then in limited situations even apply for a travel document, but that will go more towards accrual of unlawful presence before the approval of the VAWA case. Now, one of the benefits thereafter with the VAWA is actually being able then, the abused person can apply for a green card, for adjustment of status. Now this can happen in two ways. One is it can be done after the grant of VAWA. And that's usually in cases where the person was actually a lawful permanent, the abuser was a lawful permanent resident. So therefore you have to wait till the priority date becomes current. The priority date is set on the date that the VAWA was filed and accepted by the Vermont Service Center, and then the visa bulletin has to be checked on a monthly basis till that priority date is current. Now, a VAWA beneficiary can even adjust even if they entered the United States illegally. And this is quite unique because that oftentimes is the reason many people are not able to adjust status in many, many other types of cases, because they entered without inspection. That is not a bar or a deal breaker in a VAWA case. Now, another way that can be filed is if it's proven that the abuser is a U.S. citizen or even was a U.S. citizen, then there can be a concurrent filing, meaning the I-360 VAWA petition can be filed with the I-485 adjustment of status application. And this is oftentimes done. But then even at times when there is a marriage to a U.S. citizen, sometimes it is just a cost issue or a cost-benefit issue, because if there's a fear that there is a problem with the good moral character or other aspects of the VAWA application, sometimes it's advisable not to file the 485, because on a denial of a VAWA, the VAWA unit, USCIS, has stated that they will not then proceed to issue a notice to appear or send the person to immigration court. But on the I-485 filing, it's a little bit more questionable. So then a denied VAWA with a denied 485 may actually lead the person to be placed in deportation proceedings. So if the case has a few issues, maybe it's best just to file the VAWA petition self-standing and alone. VAWA issues are quite complicated, so we definitely recommend that if you're in this situation, speak to a competent and experienced immigration attorney about your options. We're definitely happy to speak to you about it. We've had great success for both men and women in situations that include physical and non-physical violence. And non-physical violence can also even include such things as where the abuser knows that he or she is a U.S. citizen and holds power over the person's immigration status and is constantly harassing them about, I'm going to call immigration, I'm going to get you deported, or filing their papers or holding a carrot over them saying that I'm going to file if this or that, but never filing. So that is an anguish and a torture that isn't tolerated and shouldn't be. So definitely, if you're unfortunately in such a situation, do seek legal help to determine what your options are. I'm Malik, and I thank you very much for watching.